Deputy Deputy Ellis.
On May the 23rd, 2012, Wicklow County Council took the shocking decision to send out letters to the residents of Brookmeadow, Avoca, which threatened them with a very large fine, which would increase if unpaid and could incur a custodial sentence. Needless to say, this brought great worry and concern to many residents who, like most of the country, do not have large funds to draw from should a county council come knocking looking for funds owed them by a developer. 3 other estates in Wicklow have been similarly affected: Avonvale Court, Emmyvale and Ockram Oaks. They were told by the council that the developers were looking, that the developers in this case were going to force the residents to pay for the sins of the developers. It is also apparent that residents in the South Dublin County Council area are receiving similar letters. The local authorities carrying out this would seem to be the first of many, considering the many developers who are absent and have not paid fees. They must not be allowed to put ordinary residents over a barrel like this. Many of these people are in negative equity, struggling to pay bills and dealing with their own issues with developers who even refuse to do essential repairs. It is estimated that $269 million is outstanding in levies from developers across the state. Something must be done to stop these charges being put onto the shoulders of ordinary homeowners, but equally so, struggling local authorities who face budget cuts and a property tax bill need to get this money from the developers responsible. They must not be allowed to go for the easy target of homeowners, but should get their levies paid by those responsible, the developer. Minister, the Department of the Environment have stated it's up to the local authority as to whether to pursue these charges. In my own area of Dublin North West, there are estates potentially liable should the local authority wish to pursue residents and not builders. Your department, the Department of the Environment, should state that this is morally wrong and unacceptable, and not pass the buck onto individual local authorities who see residents as the only target available. There are residents in unfinished estates across and many in negative equity. Residents are being asked to pay a price for services that they are not responsible in terms of delivering. Thank you.
Okay, Deputy Brian Stanley.
Thanks, John Corley. The concern I have here is that that we will see this spreading across the counties like Kildare, Laois, Offaly, Westmeath, and counties like that. This development where the County Council in Wicklow is going after the people who purchased the houses, people who are now in negative equity. The developer got their money. The banks is getting their money. Everybody's got paid. The householders are getting screwed. Again, along with carrying the bank debts, they're now going to carry the debts of the developer as well that they left behind them. And this situation can't be allowed to happen. These people, when they bought their houses, they paid 200,000, whatever figure for them. The development levies were included in that. That's how it works. They're not an add-on. They're part of the sale price. The certificate of compliance was issued to the purchasers. And in that certificate of compliance, that was falsified. Whoever falsified it is at fault, or the developer or the person acting on their behalf. That's who is at fault here. It's an absolutely scandalous situation. And the other thing here in relation to this is that bonds, local authorities have allowed bonds to lapse. They've allowed bonds to roll over to the next phase of development without the original phase, without the first phases of the development being completed. Bonds have been inadequate. Bonds have been allowed lapse. That's the fault of local authorities. They should be wide awake to this, and they shouldn't allow this to happen. And either the developer, if they're gone, if the developer is there, in whatever shape or form, they're responsible for this money. If they're not there, the receiver is responsible. And if they're not, the financial institution or the purchaser of what's left is responsible. This is a terrible situation. It's an awful vista to be coming down on top of people. And I think that, that if local authorities didn't collect them incrementally, or in whatever way that was necessary to get the money in, the local authority has funked it. The local authority has not carried out their statutory responsibilities in a proper manner. And they have been too accommodating of developers. It's been the developers were the kings. You couldn't say boo about a developer. You couldn't question anything. Those of us that tried to question what was going on were shouted down and were drowned out. Now we see the consequences of this, and here is the latest phase of it, where decent householders who are paying huge mortgages, for houses that are worth a fraction of what they bought them for, on lower wages than they were on at the time they bought it, are now faced with discharge as well. This has to be lifted off their shoulders, Count Corley. You know, the Minister and the Government have to step in here and say to the local authorities, be it Wicklow County Council, be it Laois County Council, or whoever else, if any other county councils may ever think of doing this, to back off, leave these people alone. This money is owed by either the developer, the receiver, a financial institution, or the new owners of these estates.
Okay, thank you, deputies. Now I call the Minister of State.
Thank you very much, Caoirle. Again, I want to thank all 4 deputies for raising this very important issue. And indeed, as soon as when I heard about it as well, I immediately sought clarification and information through my department officials. And I just want to, first of all, I suppose, address the Wicklow situation specifically. And it's important to say in the first instance that Wicklow County Council has also initiated separate legal action against the original developer seeking payment of the full amount outstanding, which runs to over €60,000. This matter is before the Circuit Court later this month, and it would be inappropriate to comment further on this aspect of it. However, I understand also that it may now be possible for the original bond, approximately €60,000, lodged by the developer, to be accessed by Wicklow County Council and used to fund the carrying out of necessary works at the estate. And I hope that a satisfactory outcome can be reached in this way. But like other deputies here, I do regret very much that what happened. In general, development contributions in housing developments are attached as a condition of planning permission and are typically therefore required to be paid by the person carrying out the development in advance of construction starting. In the case of one-off houses, the developer and the homeowner is generally the same person, so the situation is different. The payment of development contributions is a long-standing part of the planning system, dating back to the Planning Act of 1963. Since the 2000 Act, each planning authority must have a development contribution scheme in place, setting out how development contributions will apply in their area. The purpose of levying development contributions is to provide a mechanism by which developers can contribute to the cost of providing public infrastructure and facilities that benefit development in the area. Wicklow County Council wrote to 24 homeowners in the Brookmeadow housing estate near Avoca in May 2012 to inform them that the Council was of the view that their properties were in breach of the planning permission as a result of non-payment of the development contribution. The letters were issued under Section 152 of the Planning and Development Acts of 2000 to 2012. These are known as warning letters and mark the initial stage in the planning enforcement process. While the adoption of the development contribution scheme is a matter for elected members of the planning authorities, and that just is a fact that each planning authority, the elected members, do adopt the scheme, I have written to all planning authorities, including Wicklow County Council and South Dublin County Council, in order to establish the approach being adopted more generally by local authorities to the issue of liability for unpaid development contributions in multi-unit housing developments. Now, I await, obviously, the replies from all of the councils, but certainly I will be returning to this issue when I get the replies. And I think deputies will also be aware that I've recently issued new guidelines in relation to development levies, which, for example, put a strong emphasis on job creation projects and on town centres. But I appreciate that this issue arises from earlier legislation and guidelines. But certainly it is a very important issue, and I do understand that deputies are seeking clarification.
Okay, I'll now return to each of the deputies, so I'll give you a minute each just to...
Thank you, Minister. I'm glad to hear that Wicklow, at least one place, is managing to get fees out of the developers. It's probably one of the few that's going to get them. But, Minister, I'm wondering, do you accept that residents are being blackmailed in this situation, because and they're being threatened that their estates will not be finished and local services will suffer and they won't get local services, that the roads and their underground systems and all those will not be completed, and that's been held against them and they're not being finished, so they're going to be deliberately discriminated against while this is going on. I think it's unacceptable, Minister, that we should adopt the position, writing to local authorities, asking them for their opinion. We should be telling them that this is unacceptable to be putting this burden on residents. Residents have paid enough. They've paid their development fees, their planning, they've paid for all their services. They deserve the same as anyone else. They don't deserve to take up the tab for any developer. And I think that should be the position that this government should be given and the department should be given to the local authorities, and we should be unequivocal in that.
Allow Deputy Stanley just.
Yes, very briefly, Councillor Corley. I think that writing to the local authorities and asking them to establish approach being adopted generally by them. I think this is the wrong way around. I agree with the previous speakers. I think that we have to establish what the legal position is. The government and this House should be telling the local authorities what should happen here. My information is that the planning permission is granted to the developer. The developer, it's a contract between the developer and the council. The contract with the purchaser is the certificate of compliance as part of that. It's issued to the purchaser from the vendor. If that was done wrongly or fraudulently, that's where the case needs to be taken up. And I just think that, that in cases where there is a default here, and I welcome the fact, I hope there is a bond here, that if it does fall back on that. But if there wasn't a bond, and if these people have no other, if there's no other option for the county council, which I don't accept there isn't another option, where's these people left? Local authorities, and I've seen it, local authorities allowed these bonds to lapse, Ceann Comhairle, and they've left housing estates and communities in an awful predicament. And, it's totally unsatisfactory. It's been totally slipshod. And to write to them and to ask them their approach, I think is a weak approach. I think it's the wrong approach with respect to the Minister. I take on board that you are trying to deal with it, but I think we need to come at this the other way around. We need to take a very, very strong position. And, from this House, it must go out loud and clear that the ordinary householders who are now in negative equity, who paid over the mark and well over the mark for these houses, must not be liable for the outstanding bills left behind by developers, some of them rogue developers.
Okay.
Thanks, Ceann Comhairle.
Very much take on board what members are saying. But the fact is that the adoption of a development contribution scheme is a function of each local authority, but they do have to have cognizance and regard for the statutory guidelines that are provided by the department. But, we do have local democracy in certain things, and we have to ensure that we protect that. But at the same time, obviously, there is a common national interest here in relation to the residents concerned, and I do take that very seriously. With regard to the planning regulator, Deputy Cowan, as you know, I did take that proposal to the committee recently. We discussed it, and I will be bringing forward an implementation proposal with regard to that recommendation of Mahon. And when I do get the answers back, because it is a function of the individual local authorities to adopt their own development contribution scheme, but as soon as I get the information back, and if there is a disparity and if there are issues that need to be addressed in some local authorities, then I will certainly take action. And I do appreciate that our role as public representatives here is to ensure that we protect the public. And the development contributions, as you say, are to be... The reason for the development contributions is that at the planning permission stage, that the developer makes contributions in order to provide for infrastructure, etc. And that is the intention of them. And I certainly agree that the intention is not that individual householders should be paying, but that the developer concerned should be paying.
Okay.